Hola, muy buenas tardes a todos. Bienvenidos a esta conferencia que va a dictar el profesor Daniel Sokol sobre regulación ex ante y competencia en mercados digitales. En nombre de la Asociación Colombiana de Derecho de la Competencia les doy la bienvenida. El profesor Daniel Sokol es profesor de Derecho de USC Gould School of Law y adicionalmente es asesor de la firma White Case. Es, además de ser un profesor muy reconocido en materia de competencia, tanto en Estados Unidos como en todo el mundo, es uno de los 10 profesores más citados, o sus papers son de los más citados en los Estados Unidos. De manera que les damos la bienvenida a esta charla. Una vez el profesor Sokol termine su conferencia, que será más o menos de unos 45 minutos o algo así, abriremos a preguntas de la audiencia. Danny, welcome. Thank you so much for being with us today. We're very excited to have you here, and we hope this is one of many talks you give at the Colombian Antitrust Association. What we'll do is after you give your talk, we're going to open the floor for people to ask questions either directly or through the chat. So the floor is yours, and thank you again.
Thank you. So just in addition to the different affiliations that you mentioned, I also am a professor in our business school. So here, the law school is literally within walking distance of the business school. So that's the biggest change between University of Florida and USC, where the buildings are next to each other, whereas in Florida, it was a 20-minute walk. But these are interesting times for competition. So we had a system in the United States, and Colombia has had a system that ultimately required some knowledge of competition law and competition economics. It was a system based on enforcement. Many of the basic thoughts as to how we've been doing things have now been challenged in a significant way. The best way I can describe this to a Colombian audience is maybe to say this is the microeconomic version of the backlash against the Washington Consensus. So if you'll recall, some 10, 15 years ago, there was significant opposition across Latin America that many of the promises of economic liberalization were not being felt by the population as a whole. While there was economic growth, there was growing inequality. While there was economic growth, it favored also certain industry sectors more than others. We've seen, I think, around the world in the last few years, a similar type of push against some kind of neoliberal economics, this time at the microeconomic level. And, you know, is it really clear what people are basically? And we wanted generally lower prices, higher quality, more innovation. Today, that's under attack. There is a sense that something has changed for the worse. These things have not always been brought together in a coherent way, but parts of it are, we're concerned about the voice of labor. And so they say monopsony, but it's clear that many of the people discussing monopsony are not so familiar with the labor economics literature, or what is a very long and robust history of antitrust law in the United States dealing with labor issues. Now, is this to say that maybe it's not as nuanced as it needs to be? That's fine, but they're saying basically the entire system doesn't make sense. they're saying with regards to platforms, which we've called other names for decades and have been addressing, whether they are shopping centers, newspapers, etc., saying we don't have an antitrust way of dealing with this. Whereas we've been dealing with it a long time, and where there has been a significant literature on platforms, even if we call them network industries. So, think about your telecommunications service being a platform industry. So what we're getting is pushback, much of it not coherent, much of it very populist in nature. In Europe and in the United States, the populism comes both from the left and the right. And this is a bit different. This looks in some ways the most like early 1930s Europe, which was a difficult time politically and economically. And we're seeing some similar pushback. I think people want something different in general. So the question is, we don't live in generalities. We live in a very competition law specific world. So what does that look like for us? So that's the teaser to maybe explain a little bit where the talk is going to go. We are going to focus then on regulation and competition in digital markets. So to a certain extent, we're seeing now regulation, whereas before we just saw enforcement. We think maybe somehow digital markets are different. So we would have to ask ourselves, are they different? If so, how are they different? And what are the maybe guiding principles? So one thing that I've asked Felipe to circulate, I have a short paper in the International Bar Association's journal. It's worth reading only because it's short, but it provides some discussion of these kinds of themes. So I think overall, from a Colombian perspective, we're seeing a shift from one of enforcement to overt regulation, and sometimes not so overt. So the DMA in Europe, clearly a move to regulation, that somehow competition law was inadequate. And the ways that we are told it was inadequate was, number one, cases take too long. And I think if you are a competition authority, the cases always take too long. If you are a company that's being investigated, you also think the cases take too long. The other concern there was somehow that market power in digital markets was somehow more durable than in other markets, and that somehow something had to be done. Some kinds of rules that look a lot like what we might think of as per se rules or very strong negative presumptions. We are seeing a shift also in the UK. I say that this is regulation light. This is what we think of as new governance or cooperative governance. It's less command and control the way that the DMA is, and much more about shared governance between the regulator and the regulated with codes of conduct. And to a certain extent, some amount of self-governance by the covered companies. In the United States, we're told that there are changes to something called antitrust law, but if you look at it, it doesn't actually look at all like antitrust as we know it, but basically changes things so that the government has much more of a regulatory function. They just don't call it regulation. And some of these bills may or may not go forward. Some of these are specific to tech, and I'll give you a sense of those. Some of them are broader, focusing on other issues. Then in the United States, the FTC is considering competition rulemaking, there is not a strong legal basis for such rulemaking. It was tried once in the history of the FTC, but then ultimately not gone through. And this was before basically we saw the rise of administrative law. And I would encourage everyone who's interested in FTC rulemaking to read, I think, a very thoughtful piece that Tom Morgan, who is both an administrative, his colleague at GW Law, Richard Pierce, has a really thoughtful piece that really works through whether or not there should be FTC competition rulemaking. And what Professor Pierce suggests is that the legal argument in favor of competition rulemaking is not particularly strong. Pierce is one of the most cited administrative law scholars in the United States and really understands the administrative state very well. In other countries, we're also seeing moves to regulation. There is a sense overall that there has to be change now, and that it's very important to do it right now. Where does that leave us? A lot of times, the push to do something immediately means that sometimes there are unintended consequences. So I will walk through what do we know. I will then explain there's a lot that we don't know, and there are certain presumptions that go in a number of directions that would just change the way we do things. I'll give an example of one of the recent pieces of US legislation. I give just a handful of areas of global background. One issue is overall is all tech companies are more or less treated the same. It's size, if you're a covered company, and the models, the business models, that is, of these tech companies are actually quite different. The markets they're in are different. There is some overlap, but really these companies all do different things in terms of their primary area. What we can say generally is they have complementary areas that are close to their core areas, but all of these companies, I think, are transitioning to new areas which had not been necessarily what has been core, but they're repositioning as market conditions change. Some of these companies, I think, are also far more under attack in terms of the current business model than others. And we already see changes. And what may hold true in the UK or in Europe or the United States does not hold true globally. So one could think of, for example, in Latin America, the strength of Mercado Libre as a significant player that is not significant in the United States. You have a number of fintech providers that are significant in Latin America that are not significant in the United States. And the same is true basically around the world. So the cast of characters is different. And so the thought of what do you regulate and why do you regulate maybe changes, because if it was that easy to leverage one's monopoly power, they would have, these platforms might have already done it globally. And the fact is they can't make it work. And in some cases, they fight against each other, sometimes more, sometimes less successfully. So cloud computing is an area which is quite fierce right now. But it's not just the GAFA or GAFAM companies. Rather, in the United States, for example, Oracle and IBM also play significant roles with regards to cloud computing, with regards to business enterprise software. So a platform is a platform, except for when it's not a platform. Again, who do we regulate? Why do we regulate? And the other reality is we're seeing increased digitization across all parts of the economy, where so many different industries are now platform industries. That had not been the case before. And those dynamics, I think, play out in very interesting ways. And there, the book to read is a book that came out 2 years ago by Michael Cusimano and Annabelle Gower that really focuses on these changes of what does it take to become a platform, how are platforms able to be successful, and how do they change over time? So that's background, generally. I want to move then to focus about competition law. Competition law has been about enforcement traditionally, which is to say, with the exception of merger control, which is ex ante, enforcement is really about ex post behavior. If there is some kind of concern, you attack it after it has happened. You focus very much on specific conduct. And we do that because the effects of competition are often mixed. When it's not mixed, it's very easy, right? We think of price fixing, for example. Very clearly anti-competitive. We have rules that are per se in most jurisdictions that tell us that it's illegal. In some jurisdictions, it's also criminal. But much of economic behavior and much of the strategic thinking within companies, the effects are more mixed. There may be pro-competitive reasons to do it. There may be anti-competitive reasons to do it. And the question is, we weigh the pro-competitive and anti-competitive. This is why we move to the rule of reason or something equivalent to that across jurisdictions, because it's not always clear what the behavior is. And what is the advantage for enforcement? I put in the second bullet point that the reason why we have ex post enforcement is because we have to weigh pro-competitive for anti-competitive rather than regulation, where we're thinking sort of ex ante beforehand. Should it be covered? Again, where it's unambiguous, the answer is, or mostly unambiguous, that's when we regulate. But we're not actually looking at competitive effects, right? We're regulating beforehand. And again, if you look at traditional regulated industries, railroad, telecommunications, energy, particularly in the old world, that made sense. And I say that because today's telecommunications are very different than the communications of, let's say, 30 years ago. I believe 30 years ago in Colombia, if you had a second phone, second landline, because everything was a landline 30 years ago. But if you had a second landline, you actually would put that in if you were selling your house, we have a second line, and that improved the valuation of the house because a second line was very valuable. Barriers to entry were very high. And so even telecommunications regulation of today looks very different than 30 years ago. Similarly, we can think of banks in Colombia or the United States or anywhere else. 20 or 30 years ago, there was very little competition. Fintech by all kinds of new players, including larger tech companies, but also smaller tech companies, has changed the balance of power with regard to traditional banking. So if we think of most countries outside the United States, of which Colombia is one of them, you had a banking sector that was highly concentrated. Companies were, so therefore there was very thin capitalization. You had to go to one of these few companies. The relationships among the banks were very tight, as they were with a handful of very powerful firms, often family-owned firms that controlled much of the economy. Fintech has fundamentally transformed that, for example. Because of changes in technology, the traditional style of regulation doesn't quite work in the financial sector, because you can have very quick entry into markets that you could not have imagined even 10 years ago, let alone 20 or 30 years ago. So when we think of competition versus enforcement, many of the models we think about on the regulatory side have their origins in these kinds of regulated industries that were very traditional industries that look a lot like your utilities, such as water, rather than dynamic industries that are fast changing. So the question is enforcement really doing its job? If it's not doing its job, is it because of lack of resources by the competition authority? Is it because the enforcers are somehow scared? Or one might even, ask corrupt, because in fact, this is the claim of some of the populists, that every enforcer effectively has been corrupted. The push in the United States particularly is against the Obama administration officials, much to the surprise of the Obama administration officials, who thought, and I think correctly so, they were doing a good job, given the tools, right? Or is it that the law doesn't allow you to go after certain kinds of behavior, but that the solution is not changes to enforcement and to law, but creating a brand new structure because there's something fundamentally different in the digital context? We have had in some countries reports about what might be fundamentally different. Many of these reports are sort of mixed. Some reports are better than others. Some basically are reports of conclusions without the kind of significant evidence that we're used to. Some maybe suggest that there may be reason to have regulation that I think are better done than others. I'm going to leave aside the question of should there be regulation. I'm going to assume that in much of the world there will be regulation. And for the rest of my talk, I'd like to focus then, what are the kinds of principles that we want to see in regulation? So the key in any kind of regulation is to make sure that you create value. Notice I'm not using the term welfare enhancement. I'm not using a traditional economics term, but I'm using more of a business term. Why? Because if you use pure economics terms, this is now seen as somehow morally illegitimate in Europe and in the United States. But I mean economics. And so you need to have regulation that's well done, because if it's not well done, it hurts innovation, which is very, very bad. And oh, by the way, can increase price and also distort non-price factors. So there's a fundamental tension that many of the things that people hate about tech platforms, that it's a multi-sided market, part of it is prices will go up. For example, if you either break up certain companies or put all kinds of very significant restrictions on them, and that's part of the trade-off. And if that's the trade-off that people want, as part of democratically elected government, they could do that. I think it's just not clear to many what these trade-offs are. And indeed, the populists go out of their way to not talk about prices going up, because they know the moment they do that is the moment that they have to be accountable for telling the truth. And that's a problem where inflation is already high. Now, There are some who argue that somehow inflation and competition law are linked. And if so, the issue there would simply be because of higher concentration, then the monopolists, somehow are extracting more of these rents. Well, if that's a problem, then inflation doesn't just appear literally in the last year. We would have seen a broader move for inflation over a much longer period of time as concentration rose, but we didn't see that. So I don't really think that there's much of a linkage, but I would refer you, for example, to Larry Summers, the former Treasury Secretary, professor of economics at Harvard, who also says this is kind of crazy talk. But we're in a world where crazy talk gets attention. And so, the reality is, you say, what about price? Innovation is more difficult to sort of prove. Price is fairly easy. And one of the reasons why I think competition authorities focus so much on price, but they also focus on non-price, was because it's easier to figure out price, at least in static competition. So one thing that's been missing, and one thing that I went through over a 20-year period, I actually went through and read every single empirical platform paper in top journals across fields: economics, finance, management/strategy, information systems, and marketing. What you see is actually, at this point, there's a significant literature. It's grown over time, and it's getting increasingly cited. If you actually look at what most competition authorities are doing, however, what do they do instead? They don't cite to this literature. It's not clear to me that they've actually read this literature. They look to law review articles written by people who have no empirical background, or who just make all kinds of claims not backed up, or they go with a lot of theoretical literature, primarily in economics. In reality, economics is a small player in this empirical literature, at least for the first 20 years of the platform literature. This, for many people, is incredibly shocking. How little of a role empirical economics has played relative to other related fields. And to the extent that we are concerned about data deserts, when we think about AI, for example, are we looking at all the right kinds of issues? Are we missing data? This is Exhibit A. Most competition authorities have totally missed the picture. And having read these works, the significant majority of them actually show pro-competitive results. That is, thinking about the value creation of platforms. Some don't, but most do. And the mechanisms of how competition works have been explored significantly, whether we look at ecosystems, the difference between the platform and an app developer. How does e-commerce work? This has not been something that competition authorities have paid much attention to. And it's a problem not paying attention to it, because it helps us better refine our thinking. What are the kind of optimal rules that we want? Even if we want regulation, what do we know so that we can better design rules based on what we think we want to get to, which I think is, in most cases, competitive markets. For some regulatory objectives, it's actually not about competitive markets. It's about helping competitors, particularly the inefficient ones, but for which there may be social reasons why you may want to help them, either because we believe fundamentally in small business, but even there are papers that show how larger platforms actually create economic empowerment for small business, whether in the fintech area, or in e-commerce, or even with regards to search platforms. So this is something that I note. one thing for a Colombian audience that's worth noting, that if you look at the schools that are the biggest producers of this work, I note, by the way, USC does make the top 10. The important thing to note, not a single one is a Latin American institution. So in the very top journals, we do not, there's two issues. Number one, we need to have economists who care about Latin America. This is not to say that there aren't papers about platforms in Latin America, but it's not about digital competition as we think about it. This is not to say that people are not doing work. This is just to say that in the very top journals, that work is not appearing. Part of this has been a data issue. People haven't had the kind of data that they needed from Latin America. In the early days, that was true. Today, it's fairly easy to scrape data. And many companies, particularly mid-sized to smaller companies, are happy to share data with academics. Why would they do that? Number one, I think they have a pro-competitive story to tell. Number two, frankly, it's free consulting because they get the answers before anybody else does. But this is a particular problem if you're a regulator in Latin America, because you're basically thinking about what do we know about other markets, which may or may not look like the reality, for example, in Colombia. And how often is it a Colombia-specific example versus a Latin American example? So we can think about this, for example, in some ways, Europe is like this, that if you create an app in the UK is a relatively small market relative to all of Europe. You're basically building a European app, not a UK app. But sometimes you actually are building a UK app because the effects are very localized effects. And so the competitive dynamics are going to be different. And I think the same probably holds true for Colombia. Sometimes it's Spanish-speaking app for Latin America. Sometimes it's going to be something specific to Colombia. The problem is we simply do not have that kind of data with which we can say that the empirical work is 100% on point. In a sense, though, we'd say, that was actually much like a lot of the industrial organization. There was never really good data from Latin America generally, and most of the papers used American data, and we made all kinds of assumptions about how markets worked, given US data. Sometimes they were true, sometimes they were less true. And I think, for example, of what at the time was a path-breaking book on competition economics written by Germán Coloma from Argentina, from Universidad SEMA. Why? Because he explored, using economics, how some of the assumptions of how markets function in the United States look different in Latin America. And that may also be the case in the digital context. So I mentioned this because I think it's something to keep in mind. Things may actually be different in Latin America, but we just don't know. But broadly, there are certain lessons that we have learned. Number one, the idea that economists have a monopoly on this study is false. In fact, they don't even have anything close to a dominant position. Other fields have done a lot more empirically. On the theory side, economists have played a significant role. And frankly, though, the questions historically that economists answered were fairly narrow, pricing on different sides of a platform. But in fact, platforms are complex. And what we've seen, and this goes to questions of why do we regulate and how do we regulate, is that network effects exist, except when they actually don't exist. So sometimes there are limits to scale, and we've seen that empirically, that after a certain amount of time, scaling up further doesn't particularly help. Sometimes we have different local effects. So for example, it's the difference between Uber versus Airbnb. In Colombia, if you use Uber, actually, I don't even know if Uber is in Colombia, but it is good. So if you take Uber and you want to go from Bogota, from the business districts to someplace else, you're only competing at a localized level. However, if you want to use Airbnb, you are looking at it globally. Maybe it's because you want, to look to rent a place for a week because you got COVID in Bogota. Maybe you want to go to Cartagena. Maybe you say, actually, we want to go to Miami for a month, 2 shots. And therefore, you need Airbnb in Miami. Airbnb and Uber, you'd say they're both sharing platforms. And I'm telling you, they're both very different. Uber is very local in terms of the demand. Airbnb is global. We also see that switching costs may differ across certain kinds of platforms. So for example, switching costs may be higher in some kinds of platforms than others. And it turns out, for example, as a result, we don't have tipping effects in some industries, though we may in others. One, where we've seen empirical work on how there is no such tipping effect, video games, which I think is now important again, given that Microsoft has announced that it would like to acquire Activision Blizzard. And I don't know if that's a case that is active in Colombia. I think it's an interesting case for a different reason, because they're not in the same market. One can say that these markets are complementary in the vertical guidelines that have now been abandoned in the United States. These were called diagonal markets. It's not a pure vertical play, but it's certainly not horizontal. I would actually put Facebook, Instagram also in that category. In the United States, it's being reframed as actually a nascent competitor. I don't think that's right. I think, much like Activision Blizzard and Microsoft, or Microsoft LinkedIn, or Microsoft Skype, these are just complementary mergers. I guess a generation ago, we would have called them conglomerate mergers, but they're actually not a traditional conglomerate either. There's real value creation. This is not like ITT that owned defense, Sheraton hotels, and all kinds of other things, or even General Electric that made toasters, turbines for electric power, and engines for airlines. And NBC television. But this is not that either. So it's complicated. And I think we've also learned empirically that data has certain limits, right? In most cases, when people say data is like the new oil, they're actually right, but not in the way they thought it was. So oil actually, believe it or not, goes stale after a while. So does data. And much like oil, you sort of refine it and mix it into new ways. You do the same thing with data. Data will not get you a monopoly in almost every setting. There are some exceptions. So if for some regulatory reason there is a data monopoly, well, then we have something. Oftentimes where you might see, not because of regulatory reasons, but for other reasons, some kind of unique data sets which you cannot easily replicate or do something close enough to it, it's going to be in areas further upstream, industrial data, which might be harder. But certainly with regard to consumer data, that's not really an issue. So finally, we can get to the guiding principles of what should regulation look like. All of this was really lead up to understanding these principles, because I wanted to explore what might be different, what do we actually know, and then we come up with principles based on that. The first one is to define the scope of the regulation. What are you actually covering? So the best way to learn in Colombia or elsewhere is just say, what's not been a success? So the DMA is not successful in this sense. The definition of the scope of regulation is really not clear. What is a covered company? Actually, it looks like it's going to cover quite a number of companies that people perhaps did not anticipate that would have been covered. That's a problem. Number two, make the purpose of regulation clear and pinned to objective economic outcomes. So why are we regulating? And is the nature of what we are regulating actually linked to why we regulate? Again, it's not clear with regard to the DMA that it passes that test. I would say this is also true of some of the US legislative proposals. Number 3, procedural fairness matters. So let me be clear. Of course, it is possible to abuse procedural rights. Cases may in fact go on too long, but there are good reasons why we want transparency in the legal process and why we want due process. Particularly, know what is it that you are being accused of violating, making sure that you have the ability to see the evidence against you, making sure that you have the ability to make an argument against that, and to do it for each step of the process. If you do not have good procedural fairness, all of your outcomes are tainted. And this is a big, big problem. These kinds of procedural fairness issues are enshrined in Europe and in the United States, and my guess is also in Colombia. The other thing is regulation has to somehow be linked in some way to competitive effects analysis. One could say economics does not die just because we're regulating. We still care about the competitive effects. We may also have a broader standard, a public interest standard, but you still care about competitive effects. If you abandon that, there's no basis for regulation, and it is potentially rife for abuse at the discretion of whoever the regulator is. That does not lead to good outcomes. Related to number 4 of economics will still matter is actually economics still matters, but in a different way. All kinds of per se bans and blanket rules that are not linked to economic analysis actually will destroy economic value. We've seen why it is that we move to some kind of rule of reason. You explain the difference between the pro-competitive versus the anti-competitive effects. If we had not been weighing them properly and regulation solves that issue, that's fine. But you still have to weigh those different issues. And the other one, the final of the 6 principles, really gets to what the last 2 slides were about. Regulation, as best as possible, should be guided by what we actually know empirically. Part of the problem is, with the rush to regulate, it was not informed by what we actually know. And so you're going to get all kinds of bad regulation where we didn't quite figure it out quite right. An example of that would be GDPR. I'm not questioning that some people want very strong privacy protection. It's also clear from survey data in Europe, people want much stronger privacy protection than they do in the United States or Asia. I haven't really seen survey data in Latin America generally or Colombia specifically. But what I can say is, I don't think it was well understood at the time that with regard to very high standards of privacy, this would impact competition. And not in the ways that I think that the drafters of GDPR foresaw, because basically it strengthened the power of larger firms. Why? GDPR is actually quite costly. So many companies would basically sell to larger companies. Why? Because by selling, they basically had the larger company deal with the regulatory costs. This was not unknown. We had seen this already, for example, in financial institutions in the early 2000s, that one aspect of Sarbanes-Oxley reform in the United States, again, I'm not questioning that we shouldn't have had reform. That kind of regulation was probably very important, but it had unintended consequences. We simply had fewer IPOs, and more companies also went private. And much that same way, I don't think that many of the drafters of the kinds of regulation that we're seeing really have thought through. And if pushed on it, they would probably say they don't care, because it's not about economics, it's about some other values that they can't quantify. So I want to give you an example of what does bad regulation look like. This would be the American Innovation and Choice Online Act. This focused only on the GAFA companies in the United States, right? Blanket bans on certain kinds of self-promotion and discrimination against competitors, even when it may be pro-competitive. So the language was broad and vague. Terrible when to have that kind of combination. Strong penalties, and very difficult to show efficiencies. This is not a winning combination for innovation. And that's a problem, because why bother to invest when you're going to be punished for it? And again, this went far beyond what a good regulatory system would look like. It would basically kill, for example, Amazon Prime, which I think most consumers like. But it would do other things too. So there's all kinds of, you might call it self-preferencing, that focuses on small businesses to allow them to grow larger. You wouldn't be able to show that in search results. It hurts particularly businesses for underserved communities. So we want to encourage small and medium-sized enterprises in Colombia and the United States. This kind of bill would kill a lot of that. It would also essentially raise the price for apps. Apps had been free, probably they'd have to start charging. I think that these are not well understood consequences, and the drafters don't really care, but I think everybody else should care. And I will stop there, because I think those principles, I think, would be very helpful, and it would solve the real kinds of regulatory failures, of which I gave you, one example in more detail, and talked a little bit also about some of the shortcomings of the DMA. I'm going to stop there, Felipe, and maybe we move to discussion.
Thank you, Daniel. It's a really illuminating talk. So I'm going to open the floor to questions. If someone wants to ask something to Danny, or otherwise I'll just introduce some topics. No sé si alguien quiera hacer alguna pregunta. La puede hacer directamente o por el chat. La puede hacer también en español, si quiere. Daniel entiende español. Entonces, también se podría hacer de esa manera.
Felipe, you could just call on people. That's what I do in class.
I will.
Por favor, levanten la mano si quieren participar para poderles abrir el micrófono.
So, Danny, you have one in the chat.
Okay. So, are the tools there? I'd say yes. If you look, so I'm not going to weigh on the specifics of these cases, but if you look at the cases filed in the United States right now, say the DOJ case against Google, it's based I'd say very much on the kinds of legal arguments that we saw in Microsoft, which was a successful platforms case. I always find it bizarre when people say, oh, we can't go up against platforms because the case law is not helpful. I don't think that's right. It's, if you have a good case, you can win these cases. So the follow-up then is, if we get past the tipping point. So this is where it becomes complicated. So do markets tip? So let's actually go back to the Microsoft example. So if we look at Microsoft today for Office, they actually have a higher market share now than they did at the time of the litigation. If it turns out that this is not a contestable market, why was there no Microsoft case brought in the last 20 years as a follow-up? There's an answer for this. Because normally when you start a new platform, you don't want to basically say, we want to be the next Microsoft. You want to say, we want to be the thing that transforms the world so that we leave Microsoft behind. And in fact, that's more or less what happened. Who beat Microsoft? It wasn't the government. It wasn't the private plaintiffs. It was Google. It was Facebook. Where are you seeing the competition? From something different, a differentiated platform. That's the thing that's missing, right, in this analysis. Product differentiation, which again is a traditional antitrust framework. So do we see platform cases that are successful? Yes. Do we see some that are not successful? Also, yes. A lot of it goes to the facts. So the question is, what is it about the case that we may not have liked? Now, that said, if we look at the Amex case in the United States, you have narrow reading of Amex, you have broad reading of Amex. Under what kind of platform settings does it apply? And we're working this out in the lower courts. So it could be, depending on the kind of platform, maybe the rules aren't working. Normally, though, we wait for the courts to really tease this out. Okay, what kind of conducts would be exploitative? So in the United States, this is an easy answer. What kind of conducts would be exploitative? The answer is none of them, because exploitative abuse is not part of US competition law. In a broader sense, where we've seen under EU competition law a resurgence of exploitative abuse, I want to leave the German Facebook case aside for a moment. Where we've seen exploitative related conduct in cases has actually not been in the platform setting, it's actually been in the pharmaceutical setting. And oftentimes with drugs that are quite old, oftentimes with drugs where the prices go up very significantly. So does that look like our platform cases? You'd say, well, how can something be zero be exploitative? And you'd say, because they're exploiting not that, but the thing that they're really charging you, which is your access to data. So it turns out, when given the choice, people freely give their data away. We do it all the time. Even now with GDPR, even now we have California state law, which is very significant for companies, that operate in the United States. In fact, I did this in class just last week. We actually went through all the disclosures that you make under California law. I showed it to my students. I said, so would you give away all this privacy because you have better recommendations for Netflix? Every last one of them. Yes, yes. It turns out we don't necessarily value privacy as much as we value the other services. So what would be exploitative about it that we don't know? Well, if we take that to its logical conclusion, all of our contracts-based jurisprudence going back 70 years with regards to what they used to call shrink wrap agreements, which then we thought of as click agreements, which are now just we automatically download, all of that as a contractual matter is illegitimate. I don't think that's right, but that would be one of the implications. Beyond that, it would be, okay, how much data would be exploitative? What's the limit to this? Now, you would be hard pressed to find an economist who has defended the Facebook decision in Germany. And in fact, the decision sort of gone back and forth, which means even under German law, which would allow this, it's not so clear. Do we think about this broadly? Unclear. I'd say we don't need to think about it as an exploitative matter. I think we can bring it under traditional exclusionary matters. So let me be clear. Can there be a data-related abuse? I actually have a handbook chapter on this. Thus far, we have not seen that in the US or Europe in terms of litigated cases for a dominance case. To a certain extent, some of the mergers suggest that we could imagine a world where that is true, but we haven't seen it yet as a litigated dominance case. That said, I have done work. So should we be concerned about privacy in some cases? I think the answer is yes, when we are using privacy defaults as a way to actually block competition. And I had a paper on that. To be sure, that is a paper that was paid for. It was one tech company against another big tech company. So for those who wonder, is there competition among tech companies? Yes, sometimes there is. So the answer is, could privacy be a facet of how we are competing? Yes, but no, we have traditional exclusionary conduct competition rules to deal with that.
Thank you, Dani. ¿Alguien más tiene alguna pregunta? Pueden hacerlas, repito, en español, y si no quieren ponerlas en inglés, y Daniel las contestará de igual forma.
Exactly. Spanish, English, you could even add, spoken or written. Do we have to talk about competition among Colombian singers, right? Like if when we wanted to overtake Shakira, we didn't want the next Shakira, we wanted Juanes. We wanted something a little bit different, right? Product differentiation. And it's amazing, 20 years later, 25 years later even, they're both still active and still topping the charts.
Danny, one of the concerns, I think ex-ante regulation has is that, as you say, no platform seems to be similar to the other one, right? And ex-ante regulation seems to be sort of an easy answer to a problem and maybe of inefficiency of authorities in winning cases before courts and being fast. So I want to get your views on how easy would be on how feasible would it be to get regulation which can be targeted to a group of companies when you have, platforms across the board?
Right. So I'll actually take your question, even make it more complicated. You're assuming that there's a single platform regulator. I would suggest in most countries there are multiple platform regulators. So fintech probably has both financial regulator dealing with the digital issues. They also then have a competition regulator aspect. They may have a privacy regulator to go with it. Who's in charge of interconnection? So here's the push and pull. On the one hand, we might say open banking is good. Let anybody interconnect even, but certainly we want data portability as part of open banking. Okay, do you have the choice, or is it done in such a way that the other, the app says, I want to have the choice, because then you're violating privacy by creating competition. So and different regulators who are regulating digital platforms have different motivations. Every financial regulator says we care about competition, but ask them what they really care about. They care about stability of the financial system more than anything else. Competition's fine unless it somehow threatens stability of the financial system. This is going to look different than what a competition regulator would care about. And some platforms are dealing with only online competition, and some are dealing with competition that is across both online and offline at the same time. So we can think, for example, e-commerce has both online and offline components. That's more complex than, say, what is, dating apps only might compete against other dating apps. Right? These are all online apps, but then you'd say, well, even there, not all dating apps are the same. And so it's more complicated. Even within regulation, who are you actually competing against? So the most vigorous competition, happens sometimes in differentiated markets with both online and offline settings, whether it's hotels versus Airbnb, Mercado Libre versus, a traditional department store. A lot of companies now are competing directly with online. So they're bypassing traditional stores or even online marketplaces, and you're buying from them directly, like Nike, for example. I don't know if they do that in Colombia, but how do we really work through regulation that covers all the companies that are really competing in the same market? So part of it is, what is it that exactly you're trying to regulate, right? Is it we're scared that some companies are just too large? Well, turns out Facebook is now under the threshold for regulation in the United States, right? So how'd that work out? But it also works out in the other direction, right? Which is that maybe companies strategically try to get very close to the edge, but not to grow too large because they don't want to compete. That might hurt with innovation. Oh, we have a question. How the high standards in data protection established by the authorities can impact the development of the market competition in the market of digital platforms, right? So high standards may be fine, but we might actually be calling something high standards, but actually doing it in a way where we treat somebody else differently that looks exclusionary. And I gave an example of how that might happen in the context of Apple saying that they believe in high privacy, and they do believe in high privacy, but there are certain actions they took that looked rather exclusionary to me. Again, privacy protection is good. Platforms caring about privacy protection also good, but we could imagine situations where it looks exclusionary. And the question is, are we just competing on privacy, or are we competing on a number of different factors at the same time? And then we haven't even gotten, Felipe, to the hard question, for which I don't have a good answer for you. How do we define these markets, right? Whether it's regulation or competition, how do we define the market, right? Is the market based on all the different sides? Well, we'll start very simple. Is it just based on one set of customers or all the set of customers, right? We have yet to fundamentally come to terms even with this basic question, with market definition. And we're seeing experimentation. Well, how do we do that on the regulatory side? Unclear. We have other questions here. Do you think regulation for digital platforms must be uniform for all countries, or each national regulation about digital platforms must be different? In the second case, how would you limit the national sovereignty due to digital platforms being somewhat ubiquitous? So we could say that in many ways, this is an offshoot of a traditional question. Why do we have competition law outside of Europe if Europe is the hardest competition regulator? The answer is because local effects matter. So absolutely, we think about how we regulate. The challenge, I think, for small and medium-sized companies is how to regulate in a smart way. get the incentives wrong, larger companies are not going to invest, quite simply. And your entrepreneurs all of a sudden say, why aren't we in Miami? Why do we bother to be in Colombia? And so it's about getting the incentives right to allow for organic domestic growth, to allow for acquisitions, of Colombian companies, either by all other multi-Latinas or by US or European companies. I will leave aside right now the possibility of acquisition by Chinese companies because there's a national security concern there that we see being played out everywhere. These are not easy questions, but essentially Colombia is competing for investment dollars with Brazil, with Chile. Well, much easier now against Chile, but it's competing for investment dollars with Mexico, for Central America. And so the question is, if Colombia is too aggressive with regulation, you will lose out relative to other areas of Latin America for venture capital dollars, for private equity dollars, for even company investment dollars. And the beautiful thing is, when the programmers are still in Colombia, it creates its own ecosystem. And in a world where people can live closer to their parents, which means, people who can also check on the children and provide additional help and, with family support and on the weekends to see them, you don't have to be in Silicon Valley anymore. What's clear as a result of the pandemic is the talent is much more mobile. So if we don't get the incentives right, the talent moves. We've seen significant outpouring. In fact, when I told people that I'd moved from Florida to California, everyone looked at me like I was crazy. Everyone says, everyone's moving from California to Florida. Why did you come? And it's a good reason, to ask the question. I went from 0% state income tax to 12.5%. What kind of crazy person would do that? I went where a gallon, I know you don't use gallon, use liter, but a gallon of gasoline was $2.40. I pay $4 a gallon in California. But the weather's nice, the people are nice, there's good Chinese food. And so there are trade-offs, but the point is, a country like Colombia has to get the incentives right. E-commerce is hugely important, for example, in Colombia, because it allows every small village artisan to essentially become a global player. If you do not properly encourage e-commerce, you don't allow for somebody in a small village to basically sell nationally and sell globally. And this kind of specialization allows for high margins because it turns out, people in the United States, et cetera, will pay a lot of money for artisanal arts and crafts from Colombia. And it allows all kinds of businesses to maybe get around other traditional bottlenecks in the economy in Colombia. So the beautiful thing is e-commerce has really created all kinds of opportunities. And we could say that there are plenty of other areas like that in Colombia that are basically only functioning because of platforms. We could think we're in touch with each other a lot more now because of platforms than before COVID, right? Because it's a little more difficult and it gives us more value to be able to connect with people this way. That might be lost. So do we think consumers should be more involved in regulatory process? It's different across jurisdictions, right? So what might work in the United States or Germany or Japan may look different in Colombia. So I guess the question would be like, to what extent are consumer and consumer groups active in telecommunications regulation or water utility regulation or postal regulation, or even, food regulation or pharmaceutical regulation? I don't know. And I think the answer really is very much based on the ability of business groups and of civil society to really be engaged and how much you want them to be engaged and on what specific topics. So I think companies have gotten much better at talking to their stakeholders. So this is the other important change. We're seeing at the company level, the big change has not been regulation by government, but essentially a kind of self-regulation. They're thinking much more about ESG and talking to different stakeholders. That may also impact what companies do with regards to digital competition. It's just too early to tell. So we have international cooperation. Here's the question. So there's, how good is the Andean competition system? I guess, Felipe, would be a question for you. How well does it function, as opposed to, say, ICN?
Not very well.
Okay. So I would say ICN is helpful in terms of, like, if authority has a question, they now know who to talk to in other jurisdictions. They can get up to speed on a topic very quickly. There are all kinds of agreements that Colombia signed with other jurisdictions to really basically allow for some kind of communication that I think is helpful. There's the Latin American competition network that's based a lot on the European competition network. My sense is that has been helpful on a number of cases where people can really get together and discuss. But you probably have a better sense of how often it's used, let's say, in Colombia.
It's more of a bilateral relationship, really, between competition agencies.
Okay.
Rather than through the Indian cooperation system.
Okay. Let's see. Next question. Do I think different data protection regulations benefit or restrict competition? The answer is yes to all of that. So data protection regulations. So how do we think about consent? Opt-in versus opt-out, we actually get different results. We have to be thinking about these issues. Sometimes it benefits competition, sometimes it restricts competition. The question is it applied uniformly? Are some companies treated differently than others? What's the nature of the safeguards? It's very important to get data regulation correct across countries. There's also, I guess, the issue of data co-location, right? Like, how do you deal with that? These are not easy issues. I'm not saying that there shouldn't be regulation. Let me be very clear. I'm not saying that. I'm simply saying it's important to really work through the rules, present the trade-offs, and make decisions based on very realistic trade-offs. Because right now, we have a lot of rhetoric of we should do something. And when you look at the implementation, there's very little thought given. Or if there is thought, people are not honest about what the trade-offs are. I'd like to hope that thought was not given rather than people are dishonest about the trade-offs. So I think that's all the questions in the chat so far. Oh, we have another one. No, well, it's actually a comment rather than a question. In my opinion, digital platforms are gaining much more market share than traditional economy at a very fast pace in a lot of sectors. Is this weakness of current regulation? So we can ask the question slightly differently. If we look at traditional monopolies in the tradable sector, like food, even food delivery, a lot of parts of the economy were ripe for disruption. We've seen it in hotels, we've seen it in taxi, we've seen it in lots of areas where the markets were already highly concentrated. We see it in finance. Fintech has been great for Latin America. All of a sudden, people have access to finance that had never had access before. All of a sudden, the cost of remittances is much lower now than it's ever been. Used to be Western Union controlled remittances. MoneyGram, a little bit. There was a Spanish company, I forget what it was called. These were the big three. Not anymore. Now, all kinds of companies can do remittances. We have blockchain that actually improves the safety, assuming, again, we have blockchain that we can trust. it's creating all kinds of possibilities in supply chain. These are not necessarily bad things. Even if companies grow quickly, that's actually what we want to see. The question is, are they behaving anti-competitively? Big in itself is not a problem. If big was a problem, literally, there's not a single industry in Colombia that is not a problem. And that's largely because Colombia is a fairly concentrated market. It's a fairly small market. There are probably somewhere between 1 to 4 players in just about every market. There has to be more than just that. So in some ways, digital is creating new opportunities. In some ways, we could imagine it might also be closing off opportunities. And that's what we have to be concerned about. And that's going to be very case specific. Regulation, taking country regulation and not popular. Oh, yeah. So in a world where there's still populist backlash against Washington consensus, where I think a lot of companies did not manage the transition in a way where the hype didn't lead to everyone getting the kind of gains that they thought, how do we deal with competition in traditional regulated industries, which are hugely unpopular, my guess. And yet at the same time, how do we promote competition of digital platforms, some of which are also highly unpopular in some ways? The answer is, it's hard. How do we level the playing field? So if the question is, some regulated industries are encumbered via regulation, that they can't do certain things, whereas other people can do things. The question is, why do we regulate them differently? In some cases, right, we might want to deregulate certain aspects. And by the way, in the United States, we did deregulate quite a bit of telecommunications and energy because the part that was fast moving, it didn't make sense to regulate in quite the same way anymore. My guess is that this is part of the difficult political discussion. And sometimes the deregulation, right, basically leapfrogs. And I'd actually say in a lot of Latin America, some of the telecommunications, the mobile providers are actually at the cutting edge of digital advertising and really using data analytics to better understand prepaid versus postpaid and how you can bundle all kinds of services together that they had never thought to do beforehand. At what point does the bundling become anti-competitive? That's going to be very specific to the company and the particular thing that they decide to do. And then also not clear in most jurisdictions, framing the issue slightly differently, right? Let's call it a discount, right? Is it tying? Is it bundling? Is it exclusive dealing? If it is a bundle, what's the nature of the bundle? And we may have a very different risk tolerance for certain kinds of policies, depending on how the case law has moved in Colombia. And so the answer will be always, it depends. That's on the enforcement side. On the regulation side, the question is, would you want to actually regulate that kind of behavior? Or would you want to regulate product design? Or do you want to leave that to companies to basically figure out product design? I would like to say things like product design, you should leave the companies to do, unless they do something anti-competitive for which enforcement makes sense. There may be, again, reasons for regulation. Political speech may be one of those areas where we want to regulate, where there are clear things that we want and don't want. But very broad and vague regulation, not there. Let's see. Is it still necessary to have competition regulation? So this is from the other extreme. This is the more super free market, Hayekian view. I think yes, competition enforcement still matters. It matters most clearly in collusion, where we still have many cases in Colombia and everywhere else. When is it tacit collusion, which is legal, versus something beyond that? Working through the plus factors where already the economy is highly concentrated. There are a few players. People have all kinds of mechanisms to promote collusion, including social factors, which you might have less of in larger jurisdictions. You know, what happens all of a sudden? You're not invited to some, well, who goes to weddings anymore? But in a world where everyone would go to weddings, right? Like, oh my God, you're the only person not invited. That's actually a better way of punishing the cartel. Why? Because this family, you know, cheated on the cartel. These are real issues, I think. But beyond collusion, I think that dominance cases are also real. They oftentimes, you know, happen. They happen in every kind of industry, and you just need really good facts to bring those cases, and you need to have political will to follow through on cases that take a long time. Some authorities have been very courageous. If I recall, it was some 15 years ago where I want to say, was it an airline merger where Colombia's agency head was fired? Was it Colombia?
Yes.
Yeah. For taking a politically uncomfortable decision that was probably the right decision.
Yes.
Yeah.
It was 20 years ago.
20, okay, yes. The time flies when you're having fun. So
I think those are the questions. ¿Alguien más tiene alguna pregunta para Dani para cerrar?
Okay, gracias.
So that you have a final one. When will you come to? Yeah.
Will you come to Colombia to draft a law regarding competition law in digital markets? This is the beautiful thing. You already have the talent in Colombia. So I actually think that the best approach always is to have local people who understand the local markets focus on drafting, and then just to get comments from the global community. But the thing I'll say, I think the Colombia, look, in Colombia, I think you've done much better than other jurisdictions in Latin America in really thinking about these very difficult questions. There's been some enforcement, there's been some investigations, and I think the authorities and frankly, the entire community is learning much more about how these markets work, under what circumstances do you have to push hard with regard to competition? When would you have to push with regard to regulation? And overall, it's good. You know, the other thing that I would simply say is, you know, I think that the next stage in Colombia is basically all your traditional engineers that were doing like mechanical engineering, they were doing industrial engineering, they should all be doing computer science now. And I think that in Colombia, you know, you have a number of important cities where people should be basically doing a lot more building of apps and creating value that way. And part of the broader competition policy, I'd like to see more of the advocacy work to make it easier to basically create a localized competition community, because the venture capital money will follow. There's a lot of venture capital money in Miami. They're looking to invest in Latin America. Look better than everybody else.
Thank you. Danny, we have 2 or 3 minutes if you want to give a final message to everyone about the questions or whatever you think is appropriate.
I'd say a few things. Number one, if you're a law school student now, the best way to train yourself is to see what's going on in other jurisdictions, but to also try to figure out the law itself is less important. It's what are the mechanisms? What's driving behavior? So I say this as someone who also teaches in a business school. You know what business schools do well? They explain what's the business strategy. If you cannot understand the underlying business strategy, you're not going to be effective, either as a regulator or enforcer, or as a lawyer for private firms. And I'd say this is true if you were going to be dealing with capital markets or with M&A or tax as much as competition. Understand the business. What's driving the business? The second thing is understand risk to the business, of which regulation matters. To a certain extent, I actually have a series of very short videos that I can send you. Let me actually see if I could put them in the chat. Let me find them. A friend of mine created a series of videos on basically on digital issues. And I'm going to look for them. And I'll actually just send it, Felipe, to you afterwards. And, you know, like, there are a lot of short videos. And I have to say, like, if you really want to understand digital regulation, read a number of books on AI. There's some good ones. So among the different videos that I like, or not videos, among the different books that I like, the one by Marco Iancidi and Karim Lakhani, I think it's called Competing in the Age of AI. I think it's really, really good. I would say another one that I like is about, it's by Agarwal, Gans and Goldfarb, and I want to say it's called Prediction Machines, the simple economics of artificial intelligence. I think that one's really, really good. I would say there's just a lot of work out there that if you want to understand digital, you actually have to understand digital. And that historically, I think, is what people have struggled with. So I would say that. I'll maybe leave it at I'll leave it at that. I don't know, Felipe, if there's something else.
Not from our side. If you want to say something else, please go ahead. If not, Danny, again, we're very excited to have you here at the ACDC. We hope to have you again very soon, talking about the different topics that you teach at the university. Again, thank you so much. This was really engaging. A lot of questions.
Yes.
So that's really good.
Great. So there's one final thing I'll say, which is that, I understand that Los Angeles is further from Miami, but if you want to come study, we have a very good group here of people who care about digital issues. And we are actually in the early stage. It should be ready, I want to say, within the next year or two. We want to have a law and economic master's focusing on innovation, law and economics. So it'll be jointly between the economics department and the law school, which basically will focus for LLMs to basically do an extra semester where they're going to get a master's degree, where they're actually going to really focus on innovation, the economics of innovation. So that's worthwhile. In the meantime, I'll just say, Los Angeles is actually better than ever I imagined it. Come visit, all of you, really.
Thank you, Danny. Thank you so much. And please do send us the information on the programs.
Yes.
I can distribute that information through
it's short videos, each one like 3 or 4 minutes long. It's great.
Excellent.
Okay. Thank
you again.
Okay.
Muchas gracias a todos por la asistencia.